A very warm welcome. Today, I, Reeya Khanna, an intern under Lexis and Company, am here virtually to explain colorable legislation under the Indian Constitution. Quando aliquid prohibitor ex director prohibitor et per obliquum. When anything is prohibited directly, it is prohibited indirectly. The doctrine of colorable legislation is based on the above maxim. Colorable legislation is understood as whatever legislation can't do directly, it can't do indirectly. Doctrine of colorable legislation, like any other constitutional law doctrine, is a tool devised and applied by the Supreme Court of India to interpret various constitutional provisions. It is a guiding principle of immense utility while construing provisions relating to legislative competence. The doctrine is built upon the founding stones of the doctrine of separation of power. Separation of power mandates that a balance of power is to be struck between the different components of the state, between the legislature, the executive, and the judiciary. The primary function of the legislature is to make laws. Whenever legislature tries to shift this balance of power towards itself, then the doctrine of colorable legislation is attracted to take care of the legislative accountability. The literal meaning of colorable legislation is that under the color or guise of power conferred for one particular purpose, the legislature cannot seek to achieve some other purpose which it is otherwise not competent to legislate on. In our constitution, this doctrine is usually applied to Article 246, which has demarcated the legislative competence of the Parliament and the state legislative assemblies by outlining the different subjects under List 1 for the Union, List 2 for the states, and List 3 for both as the concurrent list. The Supreme Court on colorable legislation. One of the most cogent and lucid explanations relating to this doctrine was given in the case of K.C. Gajapati Narayana Dio and others versus the state of Odisha. If the constitution of a state distributes the legislative powers among different bodies, which have to act within their respective spheres marked out by specific legislative entries, or if there are limitations on the legislative authority in the shape of fundamental rights, questions do arise as to whether the legislature in a particular case has or has not, in respect to the subject matter of the statute or in method of enacting it, transgressed into the limits of its constitutional powers. Such transgression may be patent, manifest, or direct, but it may also be disguised, covert, and indirect. And it is to the latter class of cases that the expression colorable legislation has been applied in certain judicial pronouncements. The idea conveyed by the expression is that although apparently a legislature in passing a statute purported to act within the limits of its power, yet in substance and in reality it transgressed these powers, the transgressor being veiled by what appears on proper examination to be a mere presence of disguise. The doctrine is also called a fraud on constitution. The failure to comply with the constitutional condition for the exercise of legislative power may be overt or it may be covert. When it is overt, we say the law is obviously bad for non-compliance with the requirement of the Constitution. That is to say, the law is ultra-vires. When, however, the non-compliance is covert, we say that it is a fraud on the Constitution. The fraud complained of being that the legislature pretends to act within its power while in fact it is not doing so. Certain limitations on the application of the doctrine of colorable legislation. Number one, the doctrine has no application where the power of a legislature are not fettered by any constitutional limitation. Number two, the doctrine is also not applicable to subordinate legislation. Number three, the doctrine of colorable legislation does not involve any question of bona fide or mala fide on the part of the legislature. The whole doctrine resolves itself into the question of competence of a particular legislature to enact a particular law. If the legislature is competent to pass a particular law, the motivates which impel to act are really irrelevant. On the other hand, if the legislature lacked competency, the question of motive does not arise at all. Number four, a logical corollary of the above mentioned point is that the legislature does not act on extraneous considerations. There is always a presumption of constitutionality in favor of the statute. The principle of presumption of constitutionality was successfully enunciated Number 5, when a legislature has the power to make law with respect to a particular subject, it also has all the ancillary and incidental power to make that law an effective one. And number 6, as already discussed above, that the transgression of constitutional power by legislation may be a patent, manifest, or direct, but may also be disguised, covert, and indirect. And it is only to the latter class of cases that the expression colorable legislation is being applied. Thank you.